Good afternoon, everyone. Thank you for attending the event and joining this session. Presenting today is Seth Holland, and he is a lawyer at Williams HR Law, LLP. Seth provides advice on a broad range of employment and labor issues and represents clients in civil claims and matters before administrative tribunals, including the Human Rights Tribunal of Ontario, the Workplace Safety and Insurance Tribunal, the Canada Industrial Relations Board, and Seth also regularly conducts workplace investigations across industries in the private, public, and not-for-profit contexts, and provides legal advice and guidance to employers conducting investigations into complaints of various nature. Good luck on your presentation today, and I'll try to circle back at the end just to help close things out, okay?
Thanks so much, Sandra. I appreciate it.
Thank you.
Hey, so getting started, Sandra, thanks for the introduction. I see, I'm sure people are going to start trickling in as we get started here. But I'll be presenting on workplace investigations. Given the half-hour time slot, it's kind of like drinking from a fire hose to get to know all the considerations for employers when it comes to workplace investigations. Because as we'll get into, it's a very hot topic. It's just about everywhere in labor and employment law nowadays. You're going to hear about investigations and investigation requirements. It's hot on employers' minds, and it's also a hot area for labor and employment lawyers like myself for that reason. So the plan today will just be to go over very briefly legal framework of investigations, sort of on a need-to-know basis, then getting into sort of the key considerations for employers. Where are the pitfalls? How do you avoid them? If you're an Ontario-based employer, I'll speak to some of the legislation, but what I speak about here today applies more generally to all Canadian employers as far as I'm concerned. So let's get started. Here's another picture of me. There you have it. There's my email at the bottom, sholland@williamshrlaw.com. Feel free to shoot me an email. Feel free to shoot me a question anytime. I'm here to answer questions. I'm here to be informative. So feel free to shoot a question throughout the presentation. I'll answer it at the end if I can. I might even answer it during the middle. I don't know. I'm still trying to figure out how to format with this hop-in format. But yeah, feel free to ask questions, and absolutely feel free to send me an email if you wish. Roadmap. Won't park here for too long, but I'll go over, like I said, when I'm talking about workplace investigations. Let's see, there's some people trickling in here. So I'll give you a sense of the current climate. What are the factors impacting investigations and pushing employers to conduct more investigations now? I'll give you a sense of the legal framework. So what's the legal standard and obligations that are on employers nowadays related to workplace investigations, because that's important to know. And then even when your legal obligations are triggered, what are the key considerations for employers when it comes to workplace investigations? So we'll finish on that. And there's a lot to talk about there, certainly. So moving on, current trends. You know, I'm not going to lecture anyone about the impact that COVID-19 has had on Canadian workers. I think we're all well familiar with that. Just a basic statistic here, but it's an impactful one. 80% of Canadians indicate that the pandemic has had some negative effect on their mental health. So 80% of Canadians, that's a substantial number of people. The impact, obviously, on Canadians of COVID, of being shut in, of not being able to go out, and then even when you're able to go out, having the risk of spreading or contracting COVID has certainly had an impact on the anxiety of Canadians. And that should be kept in mind when we're talking about investigations, when we're talking about workplace conduct, because it all ties in. It's all related, in my opinion, and I think the statistics show that. At the same time, since the start of the pandemic, and I can certainly attest to this through through my practice and in performing workplace investigations, we've seen an uptick in complaints of harassment, complaints of sexual harassment and discrimination in the workplace. We have definitely seen an uptick at this time, commensurate with the start of COVID in March 2020. We've certainly seen been retained to conduct more workplace investigations than certainly as long as I've been a lawyer. So with that being said, that's something that should be on employers' radars at this time. We're seeing more of these complaints, and I think to say that it's completely unrelated to the increased anxieties in Canadians due to COVID-19, I think that would be inaccurate to say that those two things aren't related. At the same time, we're also seeing increased scrutiny from courts, from adjudicators, think the Ontario Human Rights Tribunal, on the way employers are responding to incidents of discrimination and harassment, right? So not only are we seeing more complaints now, we're actually seeing courts and adjudicators come down harder on employers when they fail to adequately respond, when their obligations are sort of triggered by a discrimination or by a harassment complaint. So as a result, it's more important than ever right now that employers are familiar with their obligations when it comes to human rights, when it comes to harassment, when you have to conduct an investigation, and then when the obligation is triggered, what do you have to do? What are the best practices when it comes to investigations? Because otherwise, employers could easily find themselves on the wrong end of a constructive dismissal claim, could find themselves on the wrong end of a harassment, they're failing to meet their harassment obligations under health and safety legislation. And then, of course, a discrimination claim before the Human Rights Tribunal of Ontario, or any other province for that matter, because generally human rights legislation, health and safety legislation, these things are applied on the provincial level. And you're going to see similar legislation, similar obligations in other provinces that you see in Ontario as well. So when I'm talking about this and employer obligations, I'm not just talking about Ontario, I'm talking about across Canada. Talking about workplace investigations here. So just getting into the legal and conceptual framework behind workplace investigations. Now, some employers may know sort of the obvious one in Ontario is harassment, workplace harassment. Whenever an employer hears the word harassment, that invokes a legal obligation under the Occupational Health and Safety Act. So harassment, many employers don't know this, but more recently, the legislation was changed to include workplace harassment in the Occupational Health and Safety Act. So what that means is under that health and safety legislation, you know, the same legislation where we would talk about WHMIS, for example, where we would talk about hazardous substances and workplace accidents that could cause injury and the obligation there, harassment is covered under that same umbrella of protections for employees in Ontario. So in Ontario, when you hear of harassment, when you learn of an incident of harassment, an employer has an obligation right away to conduct an investigation that is appropriate in these circumstances. The thing is, it doesn't just apply for harassment. It also applies for discriminatory conduct, an obligation for an employer to look into that and to address that conduct under the Human Rights Code as well. But investigations can arise in other situations as well, where an obligation may arise specifically in the course of misconduct, right? So anytime an employer wants to discipline an employee, anytime an employer wants to assert just cause for serious misconduct, an employer is going to have a very difficult time relying on that conduct if they haven't investigated the particular misconduct. So when we talk about investigations here, when we talk about key considerations when it comes to investigations throughout this presentation, I would apply that across the board to not only a harassment, discrimination type situation, but also a just cause situation, investigation into misconduct. It applies equally, in my view. So as I was mentioning, the legal standard under the Health and Safety Act is a, quote, investigation appropriate in the circumstances. Quite a broad term. However, that really applies more generally, even if we're talking about a harassment investigation, if we're talking about an investigation into misconduct, there are certain key considerations that you're going to want to meet, and that's going to guide an assessment of whether the investigation is appropriate in the circumstances, and we'll get into that. So what are the consequences? Something I hear all the time speaking to clients is, okay, so what? What happens if I don't conduct the investigation? Right? I mean, let's look at this. Investigations, they take up a lot of time, right? They can be, employers will at times view them as disruptive because things need to halt. Sometimes employees need to be moved. Sometimes they need to be separated. Sometimes an employee is placed on an administrative suspension, right? So sometimes employers are hesitant to get into it. The consequences, though, obviously, first, if you don't conduct an investigation when you need to, it can result in legal claims. I already touched on that a bit, but it could result in a constructive dismissal claim. It could result in a discrimination claim under the Human Rights Code. It could also result in penalties and fines under health and safety legislation if you're dealing with a harassment complaint. So there's a number of ways you can be exposed to legal consequences, legal liability, if you fail to conduct an investigation when you're legally obligated to do so. And what does that come with? Legal liability comes with cost, right? Not only by way of liability, and by the way, as I mentioned, courts are scrutinizing investigations more and more nowadays. More recently, in 2020, we recently saw an employer get hit with a $170,000 general damages award against them by the Human Rights Tribunal of Ontario in a decision NK v. Botchik. I won't get into the facts of the case, but the long and short of it is the employer failed to conduct an adequate investigation into a complaint of sexual harassment. Where that was found to have happened, the employer got hit with a very large damages claim against them. So this is really the trend that we're seeing in the law. Higher scrutiny on investigations and higher cost consequences for employers who are on the wrong side of these of their obligations. So as well, and I don't want to look past the fact that it could also result in legal costs to employers, right? You're not only receiving claims, but it costs you money to fight these claims, right? So if you're looking at the bill of a potential investigation, okay, well, there's benefits to an investigation, right? You're addressing the conduct at its root, first of all. But second of all, you might it might cause more general practical benefits to your workplace, because if you have a supervisor who's running rampant throughout the workplace, harassing and discriminating against people, whatever the conduct is, you're going to want to address that, right? So that's what I'm always telling to employers. Look at an investigation situation as an opportunity, right? You have an opportunity to address a root problem, a root cause of a problem that you might not otherwise have been aware of, right? So it really is an opportunity, and I think it should be viewed in that way. And at the same time, the point I was getting at originally, you might be avoiding legal costs down the road. If you investigate now, spend the money up front, you might be avoiding some legal costs in fighting some litigation for a wrongful dismissal, constructive dismissal, discrimination claim down the road. So backlash is the next consequence of failing to investigate. Obviously, failing to meet your legal obligations, failure to address harassing, discriminatory conduct in the workplace can result in internal strife, right? And that's going to cause practical, potentially legal issues for you, for disgruntled and aggrieved employees. Failure to investigate could also result in impact on employee wellness, right? It could also have an impact on the credibility you have as an employer, sort of getting word out there that the employer failed to meet its obligations under human rights legislation or under health and safety legislation. That can necessarily result in a loss of credibility as an employer, right? And making it more difficult for you to implement other measures and policies down the line, right? And once you lose that credibility as an employer, it's very hard to get it back in some circumstances. Lastly, the other potential consequence of failing to investigate when you need to and meeting your obligations could be an impact on your brand, reputation. I don't need to tell everyone about social media and how quickly a negative story about a company or organization can just proliferate. It can get out. It can be huge. There's even cases. I mean, it's very common to pick up a copy of the Toronto Star, National Post at this time and see a story about a harassment or discrimination claim in a workplace, right? In a very well-known employer, right? This is something that news media is picking up on now. So I don't think that employers should look past these, particularly if you're in a front-facing organization that has a very public presence, if you will. That's another consideration you should be making before choosing not to investigate. So moving on. So we talked about the legal framework behind investigations. So So even if you have the legal obligation, what does that mean? How do you conduct an adequate investigation? How do you meet your obligations in this respect, right? It's one thing to know you have to investigate. What do you do now, right? So first thing I would say you need to consider is the procedural requirements. And what the procedural requirements entail is a number of things. There's a number of procedural requirements you need to make. The first is following your workplace policy, right? So a lot of times with the recent legislation that came out in Ontario a few years ago, mandating a harassment policy, employers were quick to draft their policies, right, and update them as necessary. But a lot of times those policies just go by the wayside. They're written, they're thrown in a handbook somewhere. No one ever thinks about it. No one knows what the thing says except the lawyer who might have drafted it, right? So when you have an investigation situation, though, you need to go back to that policy and you need to look at what the obligations are on an employer, right? Because a lot of times the policies stipulate certain processes that need to be followed, right? And if you're an employer and you investigated, and then on the other side, say the matter escalates for one reason or another, if you have failed to follow the procedures in your workplace policy on harassment, that could potentially come back to bite you on the other end. So even if you investigated properly in other respects, if you failed to follow certain steps that you've outlined in your own policy, it could be viewed as a flawed process, and an aggrieved employee could kick tires at your investigation process. Next, obviously, is procedural fairness. This is sort of a catch-all term that's thrown around a lot, but there are specific meanings behind procedural fairness. So really, an investigation should be viewed with the seriousness of an adjudication proceeding, right? Both parties should be given a full and fair opportunity to give their evidence. The respondent specifically should be given the opportunity to respond to the allegations made against them, the identity of the people who have made the allegations, and that's one area that employers often miss, right? Keeping things anonymous. In most cases, that's not going to be adequate. The identity of the person making the allegation, in most cases, will need to be disclosed, as well as the evidence. A respondent, a person who is the subject of the investigation, should be made aware of all the evidence that's been put against them. These are all elements of procedural fairness that should be met. And then obviously, as an investigator, you can't prejudge the findings of the investigation, right? And if there's any suggestion that the investigator has prejudged the findings of the investigation before they actually come to findings and communicate those findings, the case law is very clear in employment law that that's going to come back to bite an employer. And any decision that they've made based on that investigation is going to be very suspect and not relied upon by a judge or adjudicator. So if there are issues in the procedure, how the investigation was conducted, how the parties were treated, that's going to be uncovered very quickly by an adjudicator assessing an investigation process. So when you're an employer, when you're an investigator, when you're going through your procedure, it's very important that you meet your procedural obligations at every step of the process. Otherwise, if the investigation ever gets challenged, you're likely going to have a problem. A couple other quick things. Confidentiality, very important. So under health and safety legislation, if you're dealing with a harassment complaint, there is actually a statutory obligation to maintain the confidentiality of all investigation-related materials. However, this should apply in any investigation, even if there isn't a strict statutory obligation there. You're going to want to maintain the confidentiality of the process. First of all, to contain the spread, right? To contain the proliferation of the allegations against a particular individual, which may not be true, right? Depending on whether they've been substantiated or not, because that can cause practical issues for the employer, for your process as well, though. Because as an investigator, when you're speaking to witnesses, you want them to come with their fresh recollection. You don't want them to come with information that's been tainted or given to them through another person, second or third hand. Timeliness is also important. So more generally, under the Occupational Health and Safety Act, an investigation should be conducted within 90 days of starting. unless there's exceptional circumstances. However, in all cases, you're going to want to get through the investigation as soon as you possibly can. That's for procedural fairness to both parties, to not leave the thing lingering. Whether you made the allegation or whether you're subject to the investigation, you have a right to a timely process and to be informed of the findings in a swift manner. So that's another thing you're going to want to be hyper aware of if you're an investigator or if you're an employer dealing with investigation. So next set of considerations is the investigator themselves, right? You can either go, there's two ways to go as an organization if you have a complaint of harassment or discrimination. You go internal, have someone internally conduct the investigation, or you can go external, right? So often what becomes an issue when an investigation is conducted is the impartiality of the investigator. That's a foundational element of an effective investigation. The investigator cannot have any bias towards one of the parties or towards a certain outcome. So when considering, and this is a decision that's going to be made by the employer in all cases, when you're considering who the investigator is going to be, you need to carefully do an assessment of the relationships in the workplace between the relevant parties, between the person who made the complaint, between the person who is the subject of the complaint. Do we have an internal person? Do we have an employee who can conduct this investigation and who is completely detached from all of the events giving rise to the investigation and who is completely detached from any personal relationship with either of the parties? If the answer to either of those questions is no, you should not be going internal with respect to your investigation. And if you do, you're running some risks of breaching your procedural obligations as it relates to the investigation. Which can result in liability, regardless of how serious the employee's conduct is, right? Because if you have a procedural hitch in your investigation, even if you can substantiate some of the allegations against the employee, if in certain circumstances, it may not be able to stick if you're trying to assert cause for, say, in the context at the end of the investigation. So another important consideration, as I mentioned, courts are more highly scrutinizing employer responses to harassment and discrimination and whether the employer has met its obligations. So the goalposts really have moved. Or the bar has been raised, whatever analogy you want to use there. It's more difficult as an employer to show you've met your obligations. There's a real strict scrutiny being placed on employers at this time. So as a result, your investigator needs to be upskilled. You need someone who is going to be able to go through the process, who understands the procedural elements there, the bias, the confidentiality, the timeliness, and how to go about assessing evidence, the order of things. It's very important that you have someone who knows how to do this. And as the conduct, as the allegations get more serious, it's really even more important if you're going to want to rely on this investigation report that you have an investigator who has some experience and who is sophisticated and knows what to do in the circumstances. Another important thing, and it's related, the law on human rights, the law on harassment and discrimination is evolving, right, along with academia. So when we're talking about discrimination specifically, the law is more prepared at this time to recognize subtle misconduct. So talking about microaggressions, micro-invalidations, those concepts, and the fact that they can give rise to a claim of discrimination, even where the conduct itself is not patently obvious, not patently egregious in and of itself. As well, trauma and investigating with a trauma-informed approach is also a big factor. It's increasingly becoming more important in workplace investigations. So assuming that an individual is more likely than not to have a history of trauma, acknowledging the role of trauma that a person has experienced, and the traumatic history of that individual, and leaving open the interpretation that trauma or someone's background can sort of inform why a particular person responded in the way that they did to a certain set of to a certain circumstance or event. So really, this leads to inconsistency in evidence. Does not necessarily mean that the witness isn't credible or reliable. Sort of investigating with a trauma-informed approach is a part of this, and it could lead to a different finding, right? An investigator who investigates through a specific informed lens in that way. So moving on, our last key consideration is after the investigation, right? So this is really more from an employer lens. I mean, after the investigation, there are at times strict legal obligations under health and safety legislation. For example, if you have a complaint of harassment covered by the Health and Safety Act in Ontario, there is a duty to inform both of the parties, the complainant and the respondent, of the results of the investigation in writing. And the Ministry of Labor directs that that be done within 10 days of the completion of the investigation. Now, this letter has to contain both the findings of the investigation and any corrective action that has been taken as a result of the investigation. So that's one thing, of course, that employers need to be on top of in the event that they're conducting a harassment investigation. However, this shouldn't really end an employer's assessment of what should be done after an investigation. So like I was saying before, an investigation, based on my experience, should be viewed as an opportunity to assess certain root causes, root problems in your workplace that need to be identified, that otherwise weren't immediately obvious to the employer. So, I mean, an obvious example for me is a supervisor who engages in inappropriate conduct that otherwise wasn't known to management, right? So obviously an investigation process too can negatively impact the workplace itself. The process itself can have a damaging impact on the workplace. So as an employer, you're going to want to engage, you're going to want to be conscious of that and engage in post-investigation restoration activities. So that could look like a number of things, right? That could look like removing certain individuals from a team or from the workplace more generally, restructuring certain teams such that so to avoid a similar problem from happening in the future. There's a number of creative solutions that an employer could come up with. Obviously, it's a case-by-case basis. You know, it could also look like training, reissuing training as it relates to harassment and discrimination in the workplace, so that all employees are on the same page, not only about their obligations, but about the expectations of the employer as it relates to harassment, as it relates to discrimination. And a related area here is supervisors, right? Because a lot of times we get into trouble as employers get into trouble because supervisors aren't adequately trained on how to escalate complaints, right? A supervisor has been just letting things slide for months, years, and it results in a harassment or discrimination claim eventually being brought that should have been escalated years ago. So now you have years worth of history that has been sort of just sitting on that supervisor's desk, but it should have been addressed years ago, right? So these types of things is where training can actually come in. The rubber hits the road, and you can actually see real benefit in having a person come in and do training and reiterate these expectations on supervisors. And it's very important for supervisors because there's actually reciprocal supervisor obligations under the Health and Safety Act. So a supervisor could technically be found to have violated the Health and Safety Act and be personally liable for certain penalties and fines. So that's something that should be hit on in training when supervisors are involved. Like I was getting at before, and sort of related, a bad investigation or a failure to conduct an investigation, though, it's going to lead to potentially more investigations, right? If you fail to address the conduct of a person who is engaging in problematic conduct, you know, we've seen it time and time again. One investigation that an employer has done in the past where they failed to address or they came to the wrong findings, it leads to more investigations because the person can be emboldened. The person, feels that the conduct is not going to be addressed, or maybe they don't even understand that it's wrong. But where it doesn't get addressed the first time, it could lead to more conduct. So really, that's why not only the investigation itself is very important, but what you do after the investigation to address the conduct is just as important, if not more important, in some circumstances. So we seem to be right on time here. And like I said, it's a bit like drinking through a hose, trying to drink through a fire hose, going through all of the considerations of a workplace investigation in a 30-minute time span, but I tried it anyways. If you have any questions, please feel free to just type it in the chat box. I know we only have a minute left here, but we also have newsletters, Williams HR Law LLP. We regularly release newsletters a few times a year. Our most recent newsletter was here in the spring. So feel free to check out our website. You can also sign up for our mailing list in which we release these things. They're very informative for HR professionals, for employment lawyers even, providing you with the latest updates in the law and practical considerations for employers. So I encourage you to check that out if you're interested. We also have a COVID-19 resource center, in which we sort of go over the recent developments for employers related to COVID-19. There's a lot of considerations there, hard to keep track of. So if that's something you're interested in, I encourage you to check that out as well. And of course, feel free to contact me at my email, sholland@williamshrlaw.com. You can just Google Seth Holland lawyer if you wish, and I should pop up through our website. And absolutely, feel free to contact me if you wish. And yeah, so really that wraps it up for me. I guess I'll wait to see if there's any questions. If you have any questions, I encourage you to write it into the box there. Otherwise, it's been a pleasure presenting to you all on a very important topic, and have a good day.
Welcome back to the Canadian Virtual Employment Law Conference. Hopefully you've been enjoying yourself.
Hi, Seth. Can you hear? Hi, Seth. Are you able to hear me? Oh, okay.
I realized I had the other tab open the whole time.
Oh, okay. I was just going to say, don't worry about it, because all I was going to do was just thank you for presenting today. Thank you for coming on our event today. And yeah, you wrapped it up nicely, leaving all the contact information, because I always just make sure that our speakers leave that. So you did that already. Yeah, so our panel starts at 3:30. If people want to head over to our main stage, and if you want to get into contact with Seth after the event, you're more than welcome to do so, obviously, with the email and social media listed over there. Is there anything else you wanted to add?
Not for me. Well, thank you for having me, Sandra. I appreciate it.
Yeah.
You've been very hospitable. And yeah, thank you for everything. Have a great weekend.
Yeah. All right. Perfect. Thank you, everyone, for watching this session.
Bye.
Bye.